In a recently filed lawsuit, 47-year-old Ternell Brown accuses the Baton Rouge Police Department of illegally taking her to a torture warehouse where they assaulted her, stripped her, and subjected her to a body cavity search. This is now the latest in a long string of allegations against the Baton Rouge Police Department regarding their use of what has become known as the Brave Cave. Let's have a look. Before we begin, I just want to let you understand what the scope of this complaint is. So, not only does Ms. Ternell Brown accuse the police department of certain acts against her, but in setting up all of the causes of action that she has against the various defendants, she also points to specific instances where this Brave Cave and its use has been a problem in the past and the police department has done nothing about it. She also points to acts by specific officers, especially her arresting officers, that were illegal. And the fact that the police department, after knowing of these numerous illegal activities, did absolutely nothing to stop the conduct. So let's have a look at the complaint. So this is a federal complaint filed, of course, by Ternell Brown. She is suing the Baton Rouge Police Department, Troy Lawrence Jr., and Matthew Wallace. Those were two of the known officers that took her to the Brave Cave, along with another unknown female officer. She's also suing Murphy Paul, the city of Baton Rouge, and the parish of East Baton Rouge. Murphy Paul, I believe, is the police chief. She begins by saying Baton Rouge torture warehouse, known to BRPD's street crimes units as its Brave Cave, was shuttered 2 weeks ago. The full horror of what the streets crimes unit did there, however, is still coming to light. Even those who were not beaten at the torture warehouse, we now know, were still sexually humiliated. Official BRPD policy greenlit in writing illegal strip searches of the hundreds of detainees brought to the Brave Cave. So she starts out strong here, alleging that not only was this Brave Cave used, but that it was the policy of the police department to allow its use for illegal searches, including body cavity searches. So let's start here at paragraph 6. On Saturday, June 10th, 2023, at approximately 5:17 p.m., members of the Baton Rouge Police Department's Street Crimes Unit were patrolling an area of the city. Troy Lawrence Jr. and Detective Matthew Wallace observed a black Dodge Charger. The officers ordered those inside the Dodge, Mrs. Brown and her husband, to stop by activating their lights. Those inside the Dodge complied by stopping. The officers ordered Miss Brown and her husband to exit the vehicle. The officers searched the vehicle without Mrs. Brown or her husband's consent or a warrant. During the search, the officers discovered several bottles of prescription medication belonging to Mrs. Brown. They opened the bottle. Mrs. Brown informed the officers a minimum of 4 times that she is in lawful possession of the pills as they had been prescribed to her. The officers informed her that it was illegal to have different prescription medicines in the same pill container. It is not illegal to have different prescription medicines in the same pill container. Mrs. Brown pleaded with the officers and informed them that she could provide proof that she was in lawful possession of the medication. Instead of viewing her prescriptions while still on scene, the officers informed her that a judge would sort it out. The officers then told Mrs. Brown, "We don't know if it's something you bought off the streets or what." The officers then forcibly, i.e. without her consent, transported Mrs. Brown to the Brave Cave. The Brave Cave is an unmarked BRPD facility depicted below that was closed in September 2023, shortly after reports of torture committed by members of the Street Crimes Unit became public. It is not a jail or a detention facility. No correctional staff work at the Brave Cave. Rather, it is a warehouse that the street crimes unit has adopted as their home base over the past several years. It is a place where BRPD takes suspects to interrogate them, gather intelligence, and attempt to flip them to begin cooperating with BRPD. Mrs. Brown was held at the Brave Cave for over 2 hours. The officers intentionally turned off their body-worn cameras at the Brave Cave, even though their investigation into Mrs. Brown was ongoing. Defendants Lawrence, Wallace, an unknown female officer, subjected Mrs. Brown to strip and body cavity searches. Defendants Lawrence, Wallace, an unknown female officer, examined her, forced her to spread her vagina and buttocks for inspection, and examined her vagina using a flashlight. Defendants Lawrence, Wallace, and unknown female officer did not have a warrant, probable cause, or consent to conduct either a strip or body cavity search. Once satisfied that Mrs. Brown was not hiding a weapon or contraband in her rectum or vagina, she was released from the Brave Cave without charge. Shortly after her release, Mrs. Brown attempted to file a complaint in person at BRPD headquarters. She was told that the officers had done nothing wrong and that her treatment was proper. So these are the allegations specifically with respect to Mrs. Brown. And we can immediately see that if these allegations are correct, that they illegally searched her vehicle because we don't see any reasonable suspicion or probable cause for a search. There's no reasonable suspicion for them to frisk her, let alone strip her and conduct a body cavity search. They unlawfully detained her by taking her to the Brave Cave. So there's numerous illegal things that were done if these allegations are true. But let's keep going. When officer defendants conducted their illegal search of Mrs. Brown's rectum and vagina, they were acting pursuant to formal BRPD policy. So this is a major problem if this is the policy of the Baton Rouge Police Department. BRPD Policy General Order Number 281 states in pertinent part, strip search. Arrestees will not be subjected to strip searches unless the officer has articulate, reasonable suspicion that this particular arrestee may have weapons or contraband on his person. Reasonable suspicion will be based on several factors. Strip searches may be conducted on non-arrestees based on individualized, articulable, reasonable suspicion to frisk. So essentially, what the policy is saying is that all the officers need is reasonable suspicion that would allow them to frisk someone, meaning pat them down for weapons, in order to conduct a body cavity search or a strip search. That's not the law. The U.S. Supreme Court has made unambiguously clear that law enforcement officers may not conduct a strip search and may only conduct a frisk as defined in Minnesota v. Dickerson, when officers have only reasonable suspicion of criminal wrongdoing. So let's have a look at what the holding in that case was. So this is Minnesota v. Dickerson. This is a United States Supreme Court case that came to them from the Supreme Court of Minnesota. And one of the holdings in the case is this. Terry permits a brief stop of a person whose suspicious conduct leads an officer to conclude, in light of his experience, that criminal activity may be afoot, and a pat-down search of the person for weapons when the officer is justified in believing that the person may be armed and presently dangerous. This protective search, permitted without a warrant and on the basis of reasonable suspicion, less than probable cause. So we're talking about reasonable suspicion is here, probable cause is here. You can get away with a frisk if you have reasonable suspicion that weapons are present or that the person is presently dangerous. But you need probable cause to go further. So less than probable cause, It is not meant to discover evidence of a crime, but must be strictly limited to that which is necessary for the discovery of weapons which might be used to harm the officer or others. So what is reasonable for a frisk is less than what is necessary to conduct a strip search. If the protective search goes beyond what is necessary to determine if the suspect is armed, it is no longer valid under Terry, and its fruits will be suppressed. So what the Supreme Court is saying there is, not only is it not a valid search, but even if you found evidence of something, you wouldn't be able to use it because you conducted the search illegally. So if this is the policy, if what we're seeing here is the policy of the Baton Rouge Police Department, that the Baton Rouge Police Department allows strip searches as long as you have reasonable suspicion that rises to the level that is necessary for a frisk. So if you have what's necessary for a frisk, you can now strip search, then that goes beyond what the case law that we just read allows, which means that everything beyond the frisk is illegal. The written BRPD policy violates the legal standard announced in Minnesota v. Dickerson for searches by police officers. Yes, it does. And apparently, here is the official policy. So this area up here where it says strip search is what we just read. And then down here, we get a little bit more. Strip searches may be conducted on non-arrestees based on individualized, articulable, reasonable suspicion to do three things: frisk, probable cause to search, consent, or a court order. Those are the four things that can lead to a strip search. One of them is reasonable suspicion to frisk. But the Supreme Court said no, that cannot lead to a strip search. Reasonable suspicion to frisk is just that, reasonable suspicion to frisk, not anything more. Anything more, and it's illegal. So immediately we have a problem here. But the plaintiff goes on. She continues to discuss the long-standing practice or custom of illegal strip searches that are carried on by the Baton Rouge Police Department. Since January 2023, BRPD Streets Crimes Unit conducted strip searches on approximately 1,000 individuals, including hundreds of individuals whose detention was based solely on reasonable suspicion of wrongdoing or less. Hundreds of these individuals, like Mrs. Brown, were released without formal arrest. Chief Murphy Paul and Deputy Chief Myron ensured that BRPD officers conducted strip search consistent with the department's own policies, that strip searches could be properly based on solely an officer's suspicion of wrongdoing. In 2018, now Deputy Chief Myron Daniels, who was then an internal affairs commander, personally shut down a meritorious internal affairs investigation into wrongdoing by Lorenzo Coleman, who was tasked with running the street crimes unit. Daniels was promoted to become Paul's deputy chief and chief of staff in 2020. Deputy Chief Myron Daniels personally defended illegal strip searches conducted by Troy Lawrence Jr. in a May 2021 press conference. So these are all defendants that are being named here. Deputy Chief Myron Daniels and Street Crimes Unit head Lorenzo Coleman operate a consulting group doing business as Armor Consulting Group, from which they gain additional income. So what is being alleged here is that the deputy chief shut down an investigation of Lorenzo Coleman, and he is in a business relationship with Lorenzo Coleman. So the boss is in a business relationship with the subordinate and controlled the investigation into his activities and shut it down. Here's the business cards. Here's the boss, Myron Daniels, and his partner, Lorenzo Coleman. Because he has a business partnership with Coleman and because the two men share an interest in maintaining their reputation as police reformers, Daniels should have recused himself from an internal affairs or misconduct investigation into the street crimes unit that Coleman oversaw. But Daniels has never recused himself from any internal affairs or misconduct investigation into wrongdoing by Coleman, the street crimes unit, or individual officers associated with the street crimes unit. Daniels remains involved in overseeing the investigation into Coleman, the street crimes unit, and the Brave Cave to this day, despite the fact that the street crimes unit operations and the street crimes unit's operations there were run by his business partner, Lorenzo Coleman. They go on to allege that the policymakers have a deliberate indifference to the consequences of the recurring misconduct by Troy Lawrence Jr. and Matthew Wallace, two of the people who were present during this particular plaintiff's strip search. Numerous incidents have involved Troy Lawrence Jr., needlessly escalating ordinary encounters, strip searching black citizens, and responding to criticism with violence. Troy Lawrence Jr. is the son of BRPD Deputy Chief Troy Lawrence Sr. Apart from Chief Murphy Paul, Deputy Chief Troy Lawrence Sr. is currently the highest paid employee of BRPD. At the time of Mrs. Brown's encounter with him, no BRPD employee with Troy Lawrence Jr.'s seniority has been suspended by BRPD more times for misconduct without being terminated than Troy Lawrence Jr. So the son is getting special treatment, apparently. At the time of Mrs. Brown's encounter with him, no BRPD employee has been suspended by BRPD more times for misconduct without being terminated than Troy Lawrence Jr. in the previous 2 years. So let's get into specific incidents. The Clarence Green incident. Shortly after joining the force, Officer Lawrence's misconduct made national news when he strip searched a minor child in public, illegally searched that child's mother's apartment without a warrant, and then threatened to beat a handcuffed detainee. BRPD conducted an investigation into Troy Lawrence Jr.'s role in the Green family case, and Chief Paul and Deputy Chief Daniels personally reviewed the results. BRPD cleared Lawrence of any violation of a use of force or search and seizure policies in connection with the initial search of, and threatened violence against Clarence Green and his brother. As Chief Paul stated at the press conference, the strip searches conducted of Green and his brother were consistent with and approved under BRPD policy. Officer Lawrence received no additional training, counseling, or anger management in connection with this incident. Officer Lawrence was never told by anyone in BRPD that he had done anything wrong by strip searching a child in public based on reasonable suspicion or less of wrongdoing. We'll skip the Shemaine Reed incident and go to the Troy Lawrence incident. Troy Lawrence tries to fight his colleagues. Officer Lawrence has twice been the subject of an internal affairs investigation for altercations with a 20-year veteran of BRPD, Cody Gunter. On July 19, 2021, Officer Lawrence disregarded a direct order from Sergeant Gunter telling him, "I don't give an F who you are." Officer Lawrence was suspended for 25 days. On March 6, 2022, Officer Lawrence called Sergeant Gunter a pedophile and attempted to fight him in public. Officer Lawrence was suspended for this latter incident as well. Lawrence and Wallace conspire in a December 2022 beating. So another incident. On December 22, 2022, local television station reported a story entitled BRPD opens internal investigation after cell phone video captures violent confrontation. The video in question depicts Lawrence repeatedly striking a handcuffed individual in the back of a police car while Wallace attempts to force his way into a house without a warrant. When questioned about the incident under oath on January 19, 2023, Officer Troy Lawrence Jr. claimed to have no recollection of the incident and no knowledge of any internal affairs investigation into the incident. He also claimed to have no idea who the man forcing his way into the house, his partner, Wallace, was. Daniels personally cleared Lawrence and Wallace of wrongdoing connected to the incident. Chief Paul's attorney was informed almost immediately after the deposition in January 2023 that Lawrence had committed perjury throughout his deposition, including, specifically, his claims that he did not recall the recent beating depicted on the video. The Chavez-Sanders incident. On October 8, 2022, Officer Lawrence picked a fight with two young men, Holden Sanders and Emmanuel Chavez, after BRPD officers shot their cousin, Malik Chavez. Officer Lawrence profanely ordered the men to leave the grounds of a hospital. When the men informed him that he was acting unprofessionally, he physically attacked both of them. The assault involved grabbing Holden Sanders by the neck and hair as Officer Lawrence unsuccessfully sought to rip him out of his car. As in this case, Officer Lawrence made up false allegations that Chavez and Sanders engaged in criminal conduct justifying his brutality. All criminal charges against both men were recently dropped. Wallace and Lawrence send Jeremy Lee to the hospital. In yet another recent incident, Wallace and Lawrence publicly stripped a young black man and then beat him so badly he was hospitalized. On January 9, 2023, BRPD arrested Jeremy Lee, who is 21 years old, 5 feet 6 inches tall, and weighs 125 pounds, without reasonable suspicion or probable cause. So they're giving you his height and weight to let you know that these two officers could easily have dealt with this particular individual without beating him. Jeremy Lee yelled in pain while Lawrence and Wallace pulled down his pants and searched him. While Mr. Lee was handcuffed and on the ground, Lawrence told him, "I am about to bat the living crap out of you." Frightened and seeking some kind of fairness, Mr. Lee told Lawrence and Wallace to turn your body-worn camera on and to bat me then. Instead of taking Mr. Lee to the East Baton Rouge Parish Prison, Wallace and Lawrence took Mr. Lee to the same torture warehouse where Mrs. Brown was sexually humiliated. While there, they took him out of a holding cell and severely beat him. Lawrence and Wallace repeatedly punched and kicked Mr. Lee. Mr. Lee was so badly beaten that authorities at East Baton Rouge Parish Prison refused to accept him when Wallace and Lawrence attempted to transfer Mr. Lee to their custody, insisting that Mr. Lee be taken to the hospital. Mr. Lee was diagnosed with broken ribs and other physical injuries as a result of his beating. Lawrence and Wallace constructed a false police report accusing Mr. Lee of attempting to escape from the torture warehouse. Lawrence accused Mr. Lee of committing a battery against him, though the narrative portion of the report does not actually claim that Mr. Lee ever touched him. Though Lawrence resigned shortly after the torture warehouse allegations became public, no disciplinary action has been taken against Wallace. Neither Wallace nor Lawrence were retrained nor disciplined following the beating of Jeremy Lee in January 2023. No officer was disciplined for the beating of Jeremy Lee in violation of BRPD policy manual, and no BRPD officer was disciplined for failing to follow BRPD policy manual orders as it relates to record of Jeremy Lee's medical treatment. BRPD Chief Murphy Paul personally received a complaint regarding the torture warehouse and Wallace and Lawrence's misconduct in January 2023. A second internal affairs complaint was received in April 2023. Tragically for Ms. Brown, it was only when the public learned of these allegations in September of 2023 that the torture warehouse was shuttered and Lawrence was forced out of BRPD. If BRPD's chief had responded to the complaints, Mrs. Brown's sexual humiliation, like the sexual humiliation of scores of other Baton Rouge citizens harmed at the torture warehouse, would not have occurred. The complaint goes on. But let's get into the causes of action. So first we have a claim under 42 U.S.C. section 1983 for unreasonable search. And essentially, Based on the foregoing allegations, Troy Lawrence Jr. and Matthew Wallace and the unknown female officer deprived plaintiff of her constitutional right to be free from unreasonable searches. That's pretty straightforward, as is the Section 1983 claim regarding unreasonable seizure, alleging that the defendant seized the plaintiff without a warrant and without probable cause, which, according to these allegations, they did. Then we get into a Monell liability claim. So that begs the question, what is Monell? Well, Monell claims derived from the Civil Rights Act of 1871. Statute 42 U.S.C. Section 1983 creates a private cause of action for damages against state and local governments and officials for violations of the U.S. Constitution and laws. These causes of action did not previously exist. For a Monell claim to survive, the plaintiff must establish that a public entity had an unconstitutional policy, either by an actual written policy or an unofficial custom or practice exercised repeatedly. So either an unwritten policy or a written policy. So let's see what the allegations are. Plaintiffs allege that BRPD maintains and implements formal written policies authorizing illegal strip searches predicated on reasonable suspicion that caused the constitutional violations alleged in this complaint. Yeah, they do. They do have that written policy. Plaintiffs further allege that there is a pattern, practice, custom, and informal policy of false arrests, excessive force, unlawful seizures, and strip searches and that this widespread recurring practice is so permanent and settled that it constitutes formal policy, and that adherence to the practice caused the constitutional violations at issue in this complaint. So even without the unlawful strip search, just the unwritten policy of use of excessive force, false arrests, unlawful seizures, and the strip searches are all unwritten policies. So if the allegations in the complaint are correct, this claim also survives. This allegation is true as well. Plaintiffs further allege that Lawrence and Matthews were inadequately trained regarding Fourth Amendment seizures and searches, that this inadequate training caused the constitutional injuries, and that BRPD and the parish city was deliberately indifferent to the constitutional rights of the injured. So, again, if the allegations in the complaint are correct, this allegation too is correct. These allegations go on. They also have she's also raised state law claims under battery, assault, intentional infliction of emotional distress, false imprisonment, and negligence. We're not going to get into those allegations because they're pretty commonplace in most jurisdictions. And you probably know what battery and negligence are. State constitutional violations. So the Louisiana Constitution apparently has similar language to the U.S. Constitution. Every person shall be secure in his person against unreasonable searches, seizures, or invasions of privacy. And her constitutional rights were violated if the allegations in the complaint are correct. They're demanding a jury trial, and of course, they want monetary damages. So, essentially, we went through this entire complaint for two reasons. One, because we want to see what specifically this particular plaintiff is alleging regarding the particular incident that occurred with respect to her, but also to show what the Baton Rouge Police Department has been doing for years and years and years. If these allegations are correct, countless people have been victim to the policies, both written and unwritten, that the Baton Rouge Police Department has had in place for probably ever. And for this type of thing to go on this long without recourse is unfathomable. But here we are. So, my take on this is that the Baton Rouge Police Department has a lot of problems. The feds are obviously investigating this. They'll probably end up in some sort of a consent decree with the federal government. A lot of these officers are probably going to lose their jobs, including the police chief. And Turnell Brown, the plaintiff in this particular case, is probably going to get a settlement. But we'll see. Let me know what you think about it in the comments below. For now, my name is Nathan Saunders, and this is The Legal Good.